rise. The Justices of the Appellate Division, Supreme Court, First Department. Easy, all persons have the business to be a part of that. Here, the defendant is done here.
You okay? Good afternoon. Welcome to the Appellate Division First Department. Oral arguments for this afternoon. It says here that the requested time is approximately 6½ hours. So let me just remind you, please only request the time that you actually need for your argument. Please keep in mind that we have read your briefs. We are familiar with your arguments, okay? People v. Jermaine Gordon. I'm sorry? 3? 4, 2, and 3. Dollar Choice versus Ross and Ross.
Good afternoon, Your Honor. For the appellant, I request 5 and 2 for 5.
5 and 2 and 5. Metviva versus the City of New York. Yes?
The respondent can have 2 minutes to address the new argument raised in plaintiff's
2 minutes. People v. Elu Romero. Submitted. Sodai versus Interactive Corp. 5, 2, and 5. People v. Jose Villa. Or Villar. Submitted. Cult versus New Jersey Transit. 10 and 5 is not brief, but yeah, respondent?
Respondent requests 12, Your Honor.
Okay. So we'll do 10 and 2 and 10. Drosh or Drosche versus Edelman and Edelman.
No appellant, right?
No appellate. Okay.
Does he want to submit?
You want to submit? I believe we're good. Submitted. Thank you so much. Morgan and Mendel versus Amster Rothstein.
Appellant, 8 and 2, please. Respondent, 7, Your Honor.
5 and 2 and 5. People v. Jonathan Gomez. Submitted. People v. Samuel Mangual. Submitted. What the dear is not here. Penthouse 2019 versus New York State Liquor Authority.
Appellant requesting 5 minutes. Respondent requests
5
5 minutes.
and 5. People versus Jesus Melendez. Submitted. Whedon versus Luxic. 5, 2, and 5. People versus Darrell Bolden. Submitted. Tomful Owners versus Hernandez. Would you like to submit? Would you like to submit?
Unless the court has questions for me, I'm happy to submit.
I think we're good. Submitted. Thank you. Naris versus Hamilton. Submitted. First case up for argument, People versus Jermaine Gordon, excuse me.
May it please the court, my name is Anjali Pathmanathan and I represent Mr. Jermaine Gordon. In this case, Your Honors, the verdict was against the weight of the evidence. Mr. Gordon was convicted of only 2 counts of endangering the welfare of a child after the jury acquitted him of all of the higher charges that the prosecution lodged against him. In doing so, the jury clearly discredited all of the relevant testimony of the prosecution's only 2 witnesses to the alleged crimes. Because those teenagers' testimonies was not believable to support any of the higher charges.
Well, the defendant was charged with forcible touching, criminal sexual act in the 3rd degree, sexual misconduct, and forcible touching. Is that correct?
Yes, and all of that was acquitted by the jury, Your Honor. And
But did not all of these charges have different elements?
they did, Your Honor, but the same alleged conduct for all of those charges that Mr. Gordon was acquitted of formed the basis for the endangering the welfare of a child counts. The prosecution never offered a different theory for the endangering the welfare of a child count, either count, excuse me. And so when all of the higher allegations were acquitted by the jury, basically because they did not find the 2 testifying witnesses credible, did not believe their testimony at trial, there's really no remaining credible testimony that supports the 2 remaining convictions.
Well, you're talking about the same conduct, but some of the conduct, or at least the elements, as I stated, are different. So for sexual touching, do you not need some type of sexual gratification or proof of sexual gratification?
Your Honor, you do, but
Okay, and then for endangering the welfare of a child or a minor, you need conduct which would likely be injurious to the individual, right? Basically, those are.
But you also need mens rea. You need the knowing.
But the mens rea for endangering the welfare would not be sexual gratification. It would just be conduct that would be injurious to the minor.
Right, Your Honor. But that knowing element is important here because it requires actual knowledge.
You're really making a repugnancy argument, aren't you?
Your Honor, I'm not making a repugnancy argument. I'm making a weight of the evidence argument for Your Honors to assess what remaining credible evidence is before this court. I mean, ultimately, the weight of the evidence review includes both an elements-based review and a credibility determination. And when you do both here, looking at the mens rea and the credibility and lack of credibility of the 2 testifying witnesses, there isn't sufficient evidence, there isn't enough evidence to prove beyond a reasonable doubt that Mr. Gordon is guilty of these 2 counts. And therefore, the verdict.
Well, the weight of the evidence review would require determination as to whether the acquittal would not have been unreasonable. So again, given the fact that we're dealing with conduct which would be endangering the welfare of a minor, conduct that's injurious to that individual, I still agree with my colleague that what you're really saying is that the verdict was repugnant.
No, Your Honor, and I can point to People v. Fisher, which is a Second Department case that really has very similar facts to this, where the Second Department said, look, this wasn't a legally insufficient verdict, but where all of the higher sexual-related allegations were acquitted against the defendant, the underlying endangering the welfare of a child count was based on the same alleged conduct. The basis for the endangering the welfare of a child count.
Your time is running out, so I want to turn your attention to something else.
Sure.
There's an order of protection against Taekwon. If we didn't agree with you on what you're saying about the weight of the evidence, is there any reason why there shouldn't be an order of protection as to Taekwon?
Certainly, yes, Your Honor. So under the CPL, under 530.13, there's just no statutory authority for this order of protection. The order of protection was issued for a person that did not testify in Mr. Gordon's trial and was therefore not a witness to any of the convictions that
But he did testify before the grand jury.
Sure, but that's essentially asserting that anyone who signs an accusatory instrument gets an order of protection, and that's not what the statute accommodates for. The
Is
statute.
signing an accusatory instrument the same as testifying before a grand jury?
Yes, Your Honor, it's sworn testimony before court, right? And the point is that that's all we have here by this witness. When the statute says that a permanent order of protection is only issued upon a conviction, and it's only issued for a witness who is a witness to whatever offense the person was convicted of, the defendant was convicted of. Here, this witness there were no convictions for Mr. Gordon for this witness, nor if the endangering the welfare of a child counts remain, nor did this witness see anything that could have possibly fallen into that category for the 2 witnesses that did testify. So there's just no statutory authority for this order of protection. So it should be vacated.
Justice Kennedy?
Thank you, Justice Weber. Counsel, if I may, what we have here, we have the two complainants that testified that the defendant attempted to touch them in their private parts. So my question to you is, why was that testimony insufficient to support a guilty verdict on the child endangerment counts? I mean, couldn't the jury indicate that there was enough proof that that was sufficient for the child endangerment counts, but not the other counts?
Your Honor, so in terms of the review of the evidence, it's not a sufficiency question. The question is whether or not it's credible. And I submit when you look at the evidence from the two witnesses that testified, these two people, they did not make any reports. The first one came out of the photo shoot. He did not report anything to the other people there. He got his hair cut. He remained in the apartment. They stayed in the apartment long after, it seems like about 2-3 hours after these allegations were supposed to have taken place. So when you look at the credibility of the testimony, it doesn't actually match up.
But the jury's entitled to accept credibility, right? So they found it credible.
Yes, Your Honor, and so
we, go with that.
Well, that is what weight of the evidence review requires, right? It requires, Your Honors, to do a de novo review of the evidence and to assert for yourselves whether or not the evidence credibly supports beyond a reasonable doubt the convictions. And I submit that they don't, based on the inconsistencies and the unreliability of some of the testimony of these two witnesses, and in terms of the entire prosecution's case, because these ultimately were the only two witnesses that came forward and testified, and what they said didn't credibly match what Mr. Gordon was convicted of.
Thank
So
you.
for that reason, the verdict should be set aside. Thank you.
Good afternoon. Emily Aldridge for the people.
Could you start with the argument as to the permanent order of protection?
Yes, Your Honor. Daniel A., cited by my adversary, described a witness as someone who had relevant information regarding, I'm sorry, this is the case I cited, described a witness as someone who had relevant information regarding the offense. And there was no indication that the person for whom an order had been issued in Rosales, which is cited in the reply brief, had relevant information regarding other charges. The court rightfully found that Taquan was a witness as designated by the court pursuant to CPL 530. He testified before the grand jury. He was the first to disclose defendant's actions inside the photo shoot. His outcry gave Damari the courage to speak out and made Markel seek evidence. It was because of this outcry that Markel knew not to accept the offer to change his underwear.
Doesn't this resolve itself, or maybe it doesn't, I want to hear what you have to say, into 530.13 4A, which says, stay away from the home, school, business, or place of employment of the victim, victims, or of any witness designated by the court of such offense. Doesn't the witness have to be someone who witnessed the offense? The offenses that the defendant is convicted of here are not offenses that Taquan was a witness of. How do you fit into that? How do you fit an order of protection as to Taquan into that statutory language?
Well, he did witness Damari's demeanor when he came back. It was also his mother was the one that called 911, which led to the police response and to the ultimate prosecution. He was essentially the catalyst for the prosecution.
When you say we witness when he comes back, but that's not a witness of the offense. It's a witness of the aftermath of the offense, but he's not a witness of such offense.
Would there ever be a situation where an outcry witness would be entitled to an order of protection? I've never seen that. And that's basically what you're arguing. You're arguing that Taquan, to some extent, was an outcry witness, and therefore he would be entitled to a permanent order of protection?
He also witnessed the excited utterances of the other boys after.
Again, so that, again, would be something that occurred after the incident, the alleged incident, and not the actual incident. I'll give you 2 minutes because well, not even 2 minutes. I'll give you a minute if you want to address the issues in terms of the weight of the evidence.
People's argument that it's imprudent to speculate concerning the factual determinations that underlay the verdict. I agree with Your Honor that this was, as I argued in my brief, this was a veiled repugnancy argument. And I also agree with Your Honor that the elements are completely different. And there certainly was, again, and I don't want to look into the jury's deliberative process. However, there is reason to believe it could have been, again, and I'm violating my own rule here, in terms of attempts to touch. And the crimes that he was acquitted of all involved completed acts. Whereas, as the court mentioned at sentencing, there was significant evidence regarding attempts to touch, which would fall under the rubric of child endangerment. If there are no questions, further questions, I'll rest of my brief. Thank you.
Thank you.
Just very briefly, Your Honor, I just wanted to point out the recent Second Department case from October. It is in my reply brief, People versus Rosales, which deals with this order of protection issue.
Well, in Rosales, the court held that the witness, the individual is not entitled to a permanent order of protection because there had been a plea by the defendant. Rosales did not deal with the situation that we're confronted with here, where the individual witness actually testified before the grand jury.
Your Honor, but what we have is a person that all the charges for that witness in Rosales, those charges were dismissed, and that's exactly what we have here.
Well, also in this case, the charges were dismissed, but the charges were dismissed by the court. The charges were dismissed not because there was any question as to whether the allegations were true or not. That question was never reached. The charges were dismissed because Taquan had an open case, and he was asserting his Fifth Amendment right, and therefore he would not be able to testify regarding the incident as to him, and therefore the people would not be able to meet their burden. So I'm wondering whether that also distinguishes Rosales from the facts here.
Your Honor, those are the facts in this case, but that doesn't make anything different from what the statute reads. The statute asks for a conviction and says that a witness can get an order of protection if they witness a crime for which...
You know whether the person who got the order of protection, whether that in Rosales had testified before the grand jury?
I don't know that information, Your Honor. What I do know is that if a person's not convicted of a crime just because someone reported a crime and maybe testified to it in a different proceeding doesn't entitle them under the CPL, section 530.13, to get a full order of protection. And for that reason, the order of protection has to be vacated. Thank you very much.
Thank you both. Dollar Choice versus Ross and Ross.
Good afternoon, Your Honors, and may it please the Court. I am Ralph Franco with Jonathan Rosenberg, PLLC, for the appellant plaintiff, Dollar Choice Deals, Inc. Your Honors, this case at once flies in the face of Court of Appeals precedent and this honorable court's precedent at the same time that it completely violates any idea of common sense that any of us could possibly have. We have a situation here, Your Honor, where $162,500 worth of merchandise was literally looted out of my client's dollar store during a time when he had notified the tenant that he wished to retain that property.
So there had been an agreement that the tenant your client would remove his or her property from the premises within a certain period of time.
That is correct, Your Honor. They were afforded, I believe the date is, I have it right in front of me here. They were afforded up to November 13th of 2018 to remove some items.
Right.
Now, of
And
course,
and your client did not do so.
well, that's somewhat disputed, Your Honor. It's actually very disputed. And
Well,
keeping in mind-
obviously, he didn't do so because you're claiming that the landlord disposed of the property. So he didn't, so your
Well,
client didn't take out the property.
He attempted to get the property on numerous occasions, Your Honor, and given the fact that we do not have a fully developed record, the court's decision in marshaling the facts against my client as a matter of law
Counsel,
is
is there any
particularly
place,
troubling.
sorry to interrupt you, is there any place in the record that reflects that your client tried to contact the landlord in the period October 25 through November 13, 2018?
That is set forth in my client's affidavit, Your Honor. Now, it's a little unclear the exact dates and times, but
Could
he
you
does
give me a
indicate-
record page number? All right, I'll look at the affidavit, okay. I did look at the affidavit.
It's a little unclear, Your Honor, the exact dates and times, but what is clear that my client averred in his affidavit that he made several phone call attempts. There had been at least some property that had been removed. And on or about November 27th of 2018, when my client learned that, in essence, there was a looting going on, and let's look at the facts, judges. The landlord wrote on the window of the premises, 50% off, everything must go. And there was video in the store of people associated with the landlord. I believe it was the
With that
daughter,
50%
son-in-law.
off, with that 50% off, that was after the time had expired for your client to remove all his property, correct? When-
That is correct, Your Honor.
Okay, so that at that point, pursuant to the court order and the agreements there, the landlord had the right to do that. I mean, it's the property still, there's still property in there, but it's past the date. And in fact, it was a few days, it was actually a few more weeks after the date that was agreed to that he did that.
I respectfully disagree, Your Honor, with the notion that the landlord had the right to do that. And I'll remind myself of my contract professor's statement to me, when you have a dispute involving a contract, first look at the language of the contract. So if we go to that part of the lease, Your Honor, which is at page 21 of the record, and we look all the way down at the end of paragraph 3, there's absolutely nothing in there that gives the landlord the right to do what they did
But
in this
then we
instance.
had an order from civil court which stated a date by which your client was to remove the property from the premises.
Agreed, Your Honor.
And again, we're beyond that date. It was beyond that date, I think at least 2 weeks beyond the date that the landlord made attempts to sell the property.
The landlord
50% on
looted
sale.
the property. I apologize for talking over you, Your Honor. The landlord looted the property. There was nothing in the civil court's order that indicated the landlord could retain personal possession
You know,
over those
calling
items.
calling it looting doesn't make it a looting. You had a specific date under the civil court order by which you were allowed to take out your stuff. Afterwards, the landlord could do what he wanted in the premises.
I disagree with that, Your Honor.
Well, hold on a second. You may disagree with that, but how about this? Did the tenant have to go back into civil court and ask for an extension of time or to
Well,
stay
shouldn't
the
he?
order?
Well, shouldn't the tenant have to do that? I mean,
The
I mean,
tenant
this
was
is a-
permitted-
This is a matter of weeks, but what if this had been months later? Would you
Your
be
Honor, this
saying
was
the
a matter
same
of
thing?
several weeks. And if I may talk to the issue of the authority of both the Court of Appeals and this honorable court's precedent, and I'd like to start out, if I could, on that point, because I think this is relevant to your question, Your Honor. So we have the case of Funding Associates, which is 277 AD 2nd, 127, a First Department 2000 case, cited by the trial court. However, in that case, judges, 7 years went by, and I see I'm running out of my time.
No,
If I
you
could
ran out of time.
May I beg the court's indulgence for one further moment?
You can finish your statement.
Thank you, Your Honor. That case involved a period of 7 years before the tenant attempted to get his property back. Far more controlling is the case of 8902 Corp. Against Helmsley Spear, Inc., which is at 23 AD 3D 316. And that case determined there was a genuine issue of fact as to whether the tenant could have his property seized in that fashion. So keeping in mind, judges, this case was decided on the papers without a fully developed record. We're talking about $162,000 worth of property
That was 2 thoughts. Thank you.
Thank you.
May it please the court, Michelle Russo on behalf of the defendant respondent Ross and Ross. In response to counsel's statement that this case was decided on the papers, that's because the plaintiff made a motion for summary judgment, so it sought to have the case decided on the papers. And in so doing, the plaintiff failed to come forward with the required evidence.
Tenant never made a motion before civil court to stay the date of the final date or sought extra time in this case? Did the tenant actually, I mean, looking at the clock and the dates, I mean, his time is going to expire soon. Was there any application by the tenant for additional time? In fact, you gave him 2 more weeks after the date that was already set in the court order. But did the tenant seek a stay of anything? I mean, was there any relief sought?
No, Your Honor, not at all. And
Kind of just let it go. It was just kind of just let days go by.
essentially, they just abandoned the property that was left on the
The
premises.
landlord didn't put the 50% sale up until after the fact, until after the time, all the
It was
appropriate
at
time
least,
periods had expired.
it was 2 weeks, yes, I'm sorry, Your Honor. It was 2 weeks after that point.
Yeah, he's looking at his stuff in his premises and it's like, okay, what do I do now?
Right, and my client had the right at that point, based on the lease. In fact, the very clause that counsel pointed to specifically provides that when the tenant is removed from the premises, any property that's remaining is deemed abandoned.
The lease provision says that you can recover property, quote, after tenant's removal, and you know that your opponent interprets that to mean tenant's removal of his property. Would you respond to that?
I think that I think that's a
It doesn't say of
for
his
construction
property.
of that, right. It says removal of the tenant, not the tenant's property. So I think it supports the landlord's position, as the motion court self-proclaimed.
The plain English meaning of that wouldn't mean removal of property, would mean removal of the tenant, wouldn't it?
That's how I read it, Your Honor, and I believe that that's how it should be read. And I would also like to point out that there is no evidence, contrary to what counsel stated, there is no evidence to dispute the fact that a demand was ever made to my client for access to the premises and that we refused to provide such access. In fact, my client's affidavit in opposition to the motion, in support of our cross motion, was not challenged by plaintiff in opposition. And they did not come forward. Any request that was made eventually was well past.
What was the judgment amount that was owed to your client? That formed the basis. What was the judgment amount that formed the basis of all this?
The rent arrears totaled $21,000 and change, I think $21,600, Your Honor, which is still outstanding, of course, but.
Okay.
But at some point in time, or during this period, the tenant did remove some property from the premises, did they not?
I'm not really sure that that's been shown, Your Honor. Not during that retrieval period?
Yes.
I don't believe so, no.
Because I thought there was something in the record that the tenant stated that they had removed some property, but they actually left a substantial amount of cash, I think $12,000 in the cash register. That they took property, but they left $12,000 cash in the register?
There was a statement that at some point in time, I don't believe, Your Honor, that it was during that retrieval period. I think it may have been at some point during the ongoing proceedings, which had commenced, I think, in December of 2016. But I don't think it was during that retrieval period. But again, it sort of begs the question of if you can't pay your rent and you presumably can't pay your vendors, do you leave cash on the premises? That's very curious. And I think it goes to the credibility in general of the defendant. I recognize that that's not an issue on a summary judgment motion. However, it does leave one to wonder. In short, Your Honors, the motion court, I believe, was correct in finding that the plaintiff did not put forth evidence to show that it had a possessory interest in the property that remained on the premises, or that my client refused a demand for access to obtain that property. And therefore, we request that the order appeal from be affirmed. Thank you.
Here.
Your Honors, the Court of Appeals case we cited in our papers, the Congregation Anchi case, tells us that fixtures are subject to abandonment. This was personal property, not subject to abandonment. The second thing is, Your Honor, you are correct that there was some personal property that was retrieved. But there are other issues.
So was that during the retrieval period, or was that before, or was that after?
During the retrieval period is my understanding, Your Honor. Again, it's a little unclear. It's not a fully developed record.
But as your adversary stated, you made the motion for summary judgment, right?
That is correct, Your Honor.
So did you come forth with anything in terms of what requests were made or demands were made?
Yes, Your Honor. That is information contained in my client's affidavit, which indicates that several phone calls were made, property had been retrieved, there was a letter sent. But I'd like to go back to the language of the...
What concerns me, or what troubles me, is that your client knew that the clock was ticking and that there was an ultimate deadline coming up. And yet, I don't see anything, unless I overlooked it, I didn't see anything in the record where your client took to get some protection or some relief from the court.
An attorney letter, Your Honor, to the defendants prior to the time...
You didn't answer my question, to the court.
Not to the court, Your Honor. One counsel to another. And may I say this, Judge, going back to Your Honors collectively.
I got a lot of binders and cases that says, you know, in terms of correspondence between attorneys, and you don't have a court order there.
Your Honor, I think that when a party is told, this is my property, don't convert it, that is sufficient. But I'd like to ask the court to consider this rhetorically. Looking at the language of this lease, would any of us putting on our lawyer hats advise a client to do what the defendant did in this case? Because I think if the answer to that question is no, then this decision simply cannot stand. There's nothing at all in the contract, in the lease, or in the case law that indicates that the defendant had the right to convert hundreds of thousands of dollars of property. We'll rest on our papers for the remainder. I beg the court's indulgence for my overtime. Thank you.
Thank you. Metviva versus the City of New York. Yes, you may proceed.
May it please the court, my name is John Moore and I represent the City of New York. In her reply brief, plaintiff abandoned the argument made in her opening brief in favor of a new argument based on a misreading of information not found in the record. This court should affirm the grant of summary judgment in this case. In her opening brief, plaintiff argued that the site, never contested that the site where she fell was a street, but simply said that it had been converted by temporary use into a playground. When the city pointed out that there was no basis in law or reason to support that argument, she changed her argument on reply and said now that the site was in fact a city park all along. An argument raised for the first time in an appellate reply brief can be rejected out of hand by this court. Moreover, it's based on a misreading of the website on which the plaintiff attempts to rely now. The website indicates that there is in fact a Coenty Slip Park, which is next to Coenty Slip, the street where plaintiff fell. Plaintiff fell on the north side in front of that street, which is at 2 Coenty's Place. It used to be a nail salon, is now a coffee shop. The south side of the street is what borders on a triangular shape.
I thought she stated that she fell in this, what she referred to as a plaza.
It's a pedestrian, so it is a street. Coenty Slip is a street that's been closed since I believe 2013 on both sides to traffic. It remains a street. It's open to pedestrian traffic, as evidenced by the fact that she was walking home on that street that day. And the argument...
She's walking to the subway.
Yes, right, walking to the subway to go home after work. The argument that this was not a street, I mean, to be clear, the street activity that she's complaining about was allowed by a street activity permit. That's on page 288 of the record. Their address of 2 Coenty Slip, that's a street address indicating that's a street. It appears on the Big Apple map. There's no doubt it's a street. Plaintiff has never contended otherwise until her misreading of a website in her appellate reply brief. Unless the court has any further questions, I'm happy to rest of my briefs.
Thank you very much.
Thank you.
Sodi versus IAC Interactive Corp. You may proceed.
Good afternoon, Your Honors, and may it please the Court. My name is Ed Kilpella, and I represent the appellants in this matter. As Your Honors are aware, this matter is up on appeal on a order dismissing the case based exclusively on releases signed by my clients when they received payouts for phantom equity they had at Hatch Labs due to previous employment in 2010, 2011, 2012. The lower court dismissed on two grounds. First, the lower court ruled against my plaintiffs that against our argument that the releases at issue did not apply to the case at all. The lower court also ruled against plaintiffs that the releases in question had been procured via fraud. The lower court's ruling was in error for two reasons. With regard to the first issue regarding the interpretation of the release in question, we intend to rest on our papers, but to say
Counsel, even before you get to the releases, didn't the plaintiffs waive any challenge to the appraisal value of the units by the terms of the plan itself?
No, Your Honor. I'm not exactly sure what term of the plan you mean, Your Honor, but no.
Well, where they give the senior participant, who's Mr. Moorjani, absolute right, I understand it.
Understood, Your Honor. Yes.
Okay.
Per the terms of the plan, the senior participant, Mr. Moorjani, who owned the largest share of phantom equity, had the sole discretion to challenge, investigate, or in any meaningful way question the valuation that was attributed to the units. And it is that relationship between IAC and Mr. Moorjani that we believe constitutes the fraud that is a fraud separate and apart from the fraud that was perpetrated against my clients, which is the underpayment of their phantom equity.
So, counsel, where in the complaint did the plaintiffs allege any fraud separate from the subject matter of the releases? Can you point us to that?
Your Honor, yes. In the complaint, it details how Mr. Moorjani engaged with IAC and was misled, or I believe the word we use is.
So, you know, that hits, I'm glad Justice Kennedy asked that, because that's the question that I've been wanting to ask. This is a 3211 motion, right?
Yes, sir, Your
It's on
Honor.
the pleadings. And we know that you can always supplement the pleadings with affidavits. Where is Mr. Moorjani's affidavit? I mean, he's supposedly aligned with you guys, right, and not with IAC. Because it's the sense I get is you're saying that IAC defrauded Mr. Moorjani, which then affected you.
Yes, sir, Your Honor.
So where's Mr. Moorjani's affidavit?
We don't have an affidavit from Mr.
Why not? Because you're supposed to be aligned in interest, aren't you? Because now you're saying about how he got defrauded, how it kind of filtered down to you. But if he gives an affidavit saying, there was no fraud, I know exactly what I'm doing.
Yes, sir.
I'm the senior investor. I call the shots.
Yes, sir, Your Honor. And Mr. Moorjani, represented by counsel, declined to provide an
Oh,
affidavit.
very good. Okay, got it.
Prior to
Thank
filing
you.
a lawsuit where we depose Mr. Moorjani, if discovery was open, we'd have the
okay.
opportunity to obtain that
But
information.
you're basing allegations on a third person, though. That's my problem. That's my concern.
We're basing our allegations, Your Honor, on two things. One, the inference that we were able to make from the complaint filed in another.
Yeah, but he's calling the shots, though. That's the problem. That's my concern. I mean, you guys agreed that he was the point person to the whole deal.
I understood, Your Honor, and Appellee's focus on Centro and its progeny for the proposition that
I strip it down to really simple essentials. When you're making allegations from somebody else, saying that somebody else got defrauded, I'd like to see at least that person's affidavit say, yeah, absolutely, I got defrauded, but I got it.
part of the reason why that affidavit might be impossible to obtain, Your Honor, is the valuation of the company at the time in question in 2014, 2015.
Well, then that leads me to the next question. If you have to go to summary judgment motion, if he's not cooperating with you, how are you even going to prove your case?
We'll subpoena him and depose him, Your Honor.
Oh, okay. Be careful what you wish for. Okay.
We're very interested in proceeding along those lines because we believe we have a case that can be made with regard to what the representations that were made to Mr. Moorjani, which we contend constitute a fraud separate and apart from the underlying fraud in our lawsuit. And as appellees point
Why
out,
wouldn't it be covered by the release?
excuse me, Your Honor?
Even if we would, let's assume that you're right about that, but why wouldn't it be covered by the release anyhow? I mean, you have such a very strong release over here, a very broad release.
Putting aside the question of whether or not the release can be invalidated on account of a separate fraud, I believe Your Honor asking what would be covered by the terms of a release if not the valuation that we're speaking about. The term used in the release, Your Honor, is interest in the units, and it's our contention that that means the ownership interest in the units. These were vesting units dependent on how long someone had been employed by the company, and so that the phrase interest in the units refers to the number of phantom equity units that were owned by any of my clients at the time of the payout. I see my time is up. Thank you.
May it please the court. Mark Zauderer for the respondent. Thank you for the opportunity. I hadn't planned to start here, but since this point was brought up by Your Honors, even if their theory was to be allowed that a supposed fraud and misrepresentation made to their agent were to be given credence, the Pasternak case, which is cited in our brief in the New York Court of Appeals, says that you cannot, in a misrepresentation case, rely on a misrepresentation made to a third party. So that would be disposed of on that. But I'd like to turn to the issue that Justice Friedman just referenced, which is, look, there are two New York Court of Appeals cases.
This theory, by the way, was it raised for the first time in plaintiff's opposition papers?
It was. That's correct. And for that reason alone, it ought to be rejected, I'd suggest. But on the fraud issue, look, there's a central fact pattern that goes through the two New York Court of Appeals cases that we cite and the jurisprudence from this court is, and they all have the same fact pattern, which is somebody makes a deal, a transaction, there's either a dispute at the time or there may be in the future. And as part of that same transaction, when money changes hands, there is a related release. And the juxtaposition in this case of the buyout of their unit interests and the release could not be clearer. And if you look, for example, all the different letters that were signed by the plaintiffs are here, and if you look in the record, it's all in the second paragraph of the settlement letter. And the first sentence talks about what the settlement amount is, and the next paragraph talks about the release, which is directly referenced to the sentence before it. So the connection and the juxtaposition could not be clearer here. And then on the other issue, does the scope, does the...
And in addition, there's the very broad language in that
Yes.
paragraph with respect
Yes, Your Honor.
It's in general very broad, but then even as to the units, with respect to your interest in the units.
Correct, Your Honor. It's directly referenced to the sentence before, and the release talks about, in relevant language, quote, any and all causes of action, suits, claims, charges, complaints, etc., and this is critical, of course, which you may now have or hereinafter can, shall, or may have. So it would cover anything that you can imagine. Now, what these cases say that I was talking about in the Court of Appeals and this court say that, and they all allege fraud. After the deal is done, the release is given, they say, wait a minute, we didn't discharge fraud. And they say here, well, it doesn't say fraud. Well, it says all causes of action. So, I mean, I could probably on these facts creatively imagine, 7 causes of action, including fraud, unjust enrichment.
No,
It
but
doesn't
that's where
need to
there's-
say fraud. It says all causes of action, and it talks about whether they have it or may hereafter have it.
Counsel, that goes into what they're saying that they were defrauded into signing the release. And that goes to my point about how I don't have anything from Mr. Mojani about all this,
Yes, that's true.
what's going on here.
Right.
I mean, that's their focal point, saying that we got defrauded into signing this release. We can't waive that. That can't be waived.
No, well, the court says, in these cases that I referenced, they say precisely the opposite. They say you can waive fraud, because every one of those cases involves a claim of fraud. And they say that, well, when I entered into this transaction and gave the release, I didn't know that you were concealing
And even
from me.
stronger, and even stronger in this case, the person that actually got defrauded would
Correct.
be the
Yes.
Mojani.
I may have misunderstood Your Honor's question, but you're right. It's an even stronger point. So unless the court has any further questions, I have nothing further. Thank you.
Just 2 points I'd like to make briefly, Your Honor. First, I don't believe Pasternak stands for the principle that was just articulated. I believe Pasternak stands for the principle that if your fraud is predicated on fraud on a third party, that fraud had to be made with the intent that that third party convey the fraudulent misrepresentations to you. And in that case, because those misrepresentations hadn't been made with that intent, the court found that an underlying fraud would not lie. That is not the case here. IAC knew that Mr. Morjani, as the senior plan participant, basically had the reliance of my clients in his back pocket. And obtaining reliance of him or defrauding him was essentially defrauding my clients. And the reliance was contractually obligated. The second point I would like to make is that in each of the cases cited by appellees in their briefs, Centro and all the others, we're talking about an arm's length negotiation between sophisticated parties where in Centro, the record indicates that the plaintiff in that case suspected they were being defrauded with regard to the valuation, yet still entered into the transaction and still signed a release. That is not the case here. None of my plaintiffs had any ability to meaningfully question, challenge, investigate anything. An analogy would be if two parties were engaged in an arm's length transaction and the purchaser engaged a third party accounting firm to ascertain the value, and that accounting firm was defrauded by the seller and then conveyed those misrepresentations to the purchaser, and then the purchaser signed a release. I don't think that fits under Centro. I think it's an exception to Centro that needs to be carved out. I think the facts of this case are much more akin to that than the facts of Centro or any of the other cases cited by appellants in their brief. And on that basis, I believe that this case should be sent back to the lower court with instructions to permit plaintiffs to investigate the fraud between IAC and the fraud on Mr. Morjani by IAC to substantiate their argument that the releases should be invalidated. Thank you.
Thank you both. Colt versus New Jersey Transit.
Good afternoon, Your Honors. May it please the court. New Jersey Transit and the appellants respectfully submit the trial court should be reversed.
This is the fifth appeal. I'm losing count now, but I think this is the fifth appeal that this court has heard.
Yes, Your Honor.
About the sovereign immunity defense, correct? And the wrinkle here, I think, that we have here is that you did in your answer serve or interpose a defense that says, along the lines, plaintiff's recovery and or claims in this litigation against defendants is barred by lack of jurisdiction over New Jersey Transit. Plaintiff's recovery should be barred as this court lacks jurisdiction, and 18 defendants are immune from suit, right?
That is correct.
So you have that in the answer, yet you waited till a little bit after Hire 3. Hire 3 is the one that we're looking at, because Hire 3 basically changed the dynamic of the sovereign immunity. Because before Hire 3, under Hall, the forum state got to decide whether or not to give the sister state sovereign immunity, correct? It was based on full faith and credit and comity.
Yes,
What
sir.
Hire 3 did was, man, I read this stuff cold. What Hire 3 did then was to shift it and gave it back to the sister state by saying the sister state controls whether or not to exercise sovereign immunity, right? So the sovereign immunity defense was always around. You made these, interposed these defenses, but they're kind of vague. I mean, you're not telling the other side exactly what's going on when you really, since Hall, had the sovereign immunity defense already there. It was existing.
Well, I'm going to speak to that directly. I appreciate the question, but I'm going to be very direct with the court.
Oh, great.
In Belfan,
Yeah.
the court said something like this: comity has been around, so you should have moved based on comity right away. That was one of the things that Belfan said. I believe
I'm not so sure I said that, but go ahead.
Well, that is my honest and respectful understanding of the Belfan opinion.
He wrote
That's
I wrote it,
I
that's
know.
why.
He might remember what he wrote.
He's,
Just a little bit.
you're the right guy to ask.
Yeah, maybe not.
And I appreciate you pointing it out. But let me say this to you. The reason why I responded forcefully there, and I have more responses than what I'm about to tell you, is because comity existed as a principle of law, but not in this case and not to this injury. Why do I say that? Because the case law that existed said that comity does not apply where a public policy of the state of New York is in play. And the case law said that when a pedestrian in New York is hit by a bus in a suit against New Jersey Transit, this isn't some abstract explanation, right? That case was on the books, Your Honor. So to say to my client, the state of New Jersey, which has sovereign rights, that we should have moved based on a illusory defense that had already been rejected.
Oh, wait a minute. It's not illusory because Hall was not illusory. That decision stood on the books for 40 years.
No, Your Honor, I respectfully, I'm not saying Hall was illusory. Hall was the Supreme Court of the United States.
Yeah, but you could have moved to dismiss based on the sovereign immunity defense. That sovereign immunity defense, you got to concede, was always around. It's not. You can't say it was illusory.
I really do disagree, and I'm glad you asked the question.
Well,
What you're saying to me is it existed based on comity, and what I am saying respectfully but arguably to you is it didn't exist.
I know. We're getting into a constitutional theoretical discussion here. Let's get down to the bare knuckles here. Your answer here, where you assert these jurisdictions, why is that sufficient? How do you argue that that's sufficient to put the other side on notice that that's a sovereign immunity defense that you're raising?
As a matter of law in the state of New York, subject matter jurisdiction or lack of it may not only be raised on any time, but it may be raised even if not pled in the
Correct. You're absolutely right about that. But sovereign immunity defense, we know, based on your Supreme Court precedent, that depending on the conduct of the person raising that defense, it can be deemed to amount to a consent. Lapidus says that.
Well, may I speak to Lapidus, Your Honor? I don't want to cut you off. But this is the heart of the legal argument as it's distinguished from
You
the
still didn't
factual.
answer my question. How do you argue that paragraph 2, 14, and 18, those three paragraphs there are sufficient to put the other side on notice that you have a sovereign immunity defense?
Well, we pled immunity, so there's the word.
You didn't plead immunity. Yes, you did.
All right,
Paragraph 18, defendants are immune from suit, right?
So that's the first answer. The second answer, and I apologize for repeating myself, is that a matter of law in the state of New York, it need not even be pled. That's the law of the state of New York, and I have not just made that up. I cited the case law and the commentaries to the procedural rule under the CPLR that says you can plead at any time, even if not in
I'll
your
buy
hands.
that.
Don't these three affirmative defenses put someone on notice that there is an issue as to the jurisdiction of New York courts?
That statement that Your Honor just made is right in isolation. I mean, that obviously, you put someone on notice when you plead something. I can't say that's not true. But respectfully, that misses the law.
It doesn't come as a surprise to the plaintiff that these defenses, when you say that you're immune, when you say there's a lack of jurisdiction, it's barred by lack of jurisdiction of New Jersey Transit. When someone reads that, it's not a great leap to come to the realization that that may encompass a sovereign immunity suit.
As a matter of law.
I mean, what did someone reading these three defenses think the pleader was talking about when they said this? It doesn't say lack of personal jurisdiction. What else might it be?
Your Honor, with great respect, I am apparently not being understood, so I apologize.
Oh, you're being understood. We understand you.
Agreeing with you.
Yeah, we understand you.
I'm not hearing it.
Well, let me ask another question. So,
Yeah.
okay,
Wait.
so we've had a number of discussions about what it says.
Yeah.
And you said, we put them on notice. All right.
Right.
But how is that so, particularly since you attended a number of discovery conferences, you asked for an extension to answer, you made a motion to compel, plaintiff to produce discovery. So the fact is, you just say, yes, we're immune from suit. Certainly, you don't say how, you don't say why, and then by your conduct, can't they rely on that you are consenting to jurisdiction? All the stuff that you didn't even raise a defense until several years after the action was commenced, a year after Henry.
Well, there's two things there, and I appreciate the question, but I really got to be direct with you.
Please.
Hyatt hadn't come out until Hyatt came out, and second, I want to
You waited
stress
a
something
year
to you.
after Hyatt came out.
a year.
It was a year after Hyatt came out that you.
Right,
put
well,
forth
I'm going to
this
give you
argument.
how that works. What happens is Hyatt comes out, the Attorney General's office that represents the state of New Jersey reviews it. They make a decision, it goes to Jersey Transit's attorneys to go to outside counsel. And that might be an exciting answer, but it is the process. But
Well, when Hyatt comes out, isn't it published in that law journal thing? So don't you read it in the law journal and say, this is interesting, this really helps us?
Yes, and as soon as we found out about it, we filed the motion. I want to read something to you with your honor's
But to
permission.
Justice Kennedy's point, you litigated for 3 years. 3 years you litigated the case. At no point in time during that 3-year period do you ever say, but remember guys, we say that we are asserting sovereign immunity. You never say that.
Your
during
Honor?
the 3-year period.
Okay, but I don't want to duck the question, but I just want to answer it.
Well, we won't let you duck it.
Yeah, I know.
You can try.
You can grill me all day, and I.
Oh, we don't have all day.
With my face, my fault.
You have 57 seconds.
All right, well, in 57 seconds, I will say this. Here's what Hyatt said. Hyatt said that the immunity at issue in this case, quote, neither derives from nor is limited by the terms of the 11th Amendment. Neither derives from nor is limited by the terms of the 11th Amendment. All of the waiver argument that you are grilling me about were based on this court's analysis of Lapidus, which is the 11th Amendment case.
I got that, because you know what? There is no U.S. Supreme Court case that addresses non-11th Amendment issues. This whole thing about sovereign immunity came out of the 11th Amendment, and historically, I understood what happened there. But there's no U.S. Supreme Court that actually touches on what happens between state and state, not with the federal court, but with the state court. So that's how I wrote Belfan, was trying to extrapolate from there. It's like, okay, so what's going on here? The bottom line is sovereign immunity. That's it.
May I respond to that question?
Please.
Because I know there's a red light on, with your permission. I do not think that I am making a leap when I respectfully say that if this were the federal trial court dealing with the 11th Amendment, you would have had a waiver law enunciated by the Supreme Court. But as Your Honor just said, you did not have waiver law enunciated. And what I'm saying to you is the trial court, an intermediate appellate court, even the New York Court of Appeals cannot carve out a waiver. If this travels to the U.S. Supreme Court, somebody smarter than me may make that argument, but with genuine and profound respect, this court cannot do it. And it is my
You're asked
uncomfortable
about the
position.
fact that you litigated for 3 years without making a motion. But on the other hand, no one ever made a motion directed against your affirmative defenses. What is this talking about? They should be stricken. What's the basis of it? That never occurred, did it?
No, Your Honor. They proceeded just like we did, and the question is on the facts, which are profoundly different than the 4 cases that were decided, should there have been a waiver, and whether this court in the first place can carve out a waiver to the United States.
I have to say, Belfan was written very carefully in the sense that I avoided the term waiver. I used the word consent. I didn't use waiver because I knew how thorny that issue, based on Justice Clarence Thomas's discussion about waiver. Because you can't waive something, it's got to be absolute consent. They have to knowingly know and consent to suit. So I really didn't use the term waiver. I didn't throw that term around that much.
Well,
so I got it.
No, that's fair, and I don't want to put words in your mouth.
Yeah,
You wrote it.
yeah,
You wrote it.
I wrote it. I know what I wrote.
You know what you wrote, but I will say that when you relied on Lapidus, I think I'm on solid ground in saying that. And what the court said with great thought was, Lapidus is instructive. And then you went on to apply Lapidus to find a waiver. I think that's accurate.
No, I went on and applied waiver saying that your conduct amounted to consent.
Based on Lapidus.
Yeah.
Right, but Lapidus is an 11th Amendment case, and the Supreme Court told you that this immunity cannot be limited by the 11th Amendment. This court cannot carve out an exception to the United States Supreme Court. You just can't. Neither can the trial court, neither can the Court of Appeals.
You're saying the federal court can carve out 11th Amendment exceptions, but we can't.
Lapidus was a United States Supreme Court case, right? So
thanks
the
for
United
reminding me.
States Supreme Court can carve out an exception,
I got it.
but the lower courts, particularly the state courts, cannot.
We're having this discussion about waiver or something which is quasi-waiver. Is there a parallelism here between what's occurring and notice of claim litigation, of jurisprudence in terms of the city of New York, where a case may be litigated and go on, and then at the end they say, well, you didn't file a notice of claim, too bad your case is dismissed. Is there any parallelism between the two situations?
Well, it's an intriguing question. The way I analyze this is as follows. The notice of claim is a prerequisite to liability. It is not a prerequisite to the location or venue of the suit. So that if there is not...
That fact can emerge late in the case to result in a dismissal of the case. Isn't
Well, that is correct. If a notice of appeal is not done properly in terms of its filing and then the time period after which, where you have to wait to file suit, even though the suit has been litigated, that's a complete...
The city doesn't lose that defense.
Yes. That is a complete defense, even if articulated and adjudicated later in the case. I see the red lights on. I will follow your instruction as how to proceed because I did intend to have some time for rebuttal.
You have 2 minutes on rebuttal.
All right, so I'll then wait for, thank you very much.
This is yours as well. May it please the court, my name is Brian Shute, I'm here for the plaintiffs. I realize, Your Honors, that the shortest distance between 2 points here is the consent issue, since you had it 4 times this past year, and all of you, with the exception of Justice Friedman, were on at least one of those panels. So I'll start there, but with the court's indulgence, because everything I'm going to say with respect to the consent issue is, I suspect, self-evident, I would like to address the other issues which the court will have before it in other cases, not just involving this defendant. The consent issue. The only factual distinction that cuts in their favor, that is claimed to cut in their favor as compared to Taylor, which the court decided last month, is that here they pleaded those 3 affirmative defenses, which aren't quoted anywhere in their main or reply briefs, but you will find quoted at page 11 of our brief. I would suggest, Your Honors, that while it may be Justice Friedman, that it's not a great leap to go from those 3 pleaded defenses to 11th Amendment immunity from suit. This is a case where the defendant is hoisted on its own petard. The papers they filed below lectured the lower court about the distinction between sovereign immunity and 11th Amendment immunity from suit. Their main brief to this court lectured the court on the difference between sovereign immunity and 11th Amendment immunity suit. That you shouldn't conflate the 2 of them. They're completely different. There are 3 pleaded defenses. You can look for 11th Amendment. You will not find it. You will find sovereign immunity, which they don't have. You will find a jurisdictional defense, which they don't have, but is no more frivolous than the defense. There were 38 pleaded defenses that they had here, including failure to state a cause of action, statute of limitations on a suit that was commenced 7 months after the incident, superseding cause, whatever that is, that was affirmative defense as well, and it goes on. 11th Amendment wasn't amongst them. In terms of the delay in Taylor, with Justice Kennedy sat, was 15 months. The delay here is almost 3 years. And with that, and I would suggest that all the other arguments about Lapidus are arguments this court had before.
Well, counsel, I have two questions. The first one, are we in fact carving out an exception? And if we are, do we, the state court, have the ability to do so?
Well, I would suggest that the court has already done so, has already stated what the law is in great length in Belfand, and in the Henry decision that was decided, I think, the same day as Belfand, and Fatoyu and Taylor last month all follow Belfand. So whatever was done there has been done 4 times. And I would suggest that 4 times is the charm. But I would like to, if the court allows.
Well, I'd like to ask you the question about how Justice Friedman asked the question, and it's a good question. There was never a motion to strike these affirmative defenses. Can you answer that? Does that cut against you?
Well, there was
all the other cases, I think conceitedly or admittedly, did not have jurisdiction as defense in their answer. But this one, has it.
Well, I think that would matter, Justice Oing, or could matter potentially only if they had actually pleaded an 11th Amendment defense. But also, as a matter of policy, are we supposed to really make separate motions to strike failure to state a cause of action? Because this is a pedestrian knockdown, it's unknown to New York law according to the defendant?
Did you move to strike any affirmative? Did you move to strike any of the affirmative defenses?
We did not, Your Honor. Nor was there such a motion to the best of my knowledge in any of the other cases as well, including Taylor, where the delay was much lesser.
The other interesting question I heard was the notice of claim analysis. Did you hear that question of the query that this is analogous to a notice of claim where you can litigate a case and then all of a sudden you can get dismissed because you never filed your notice of claim? How do you respond to that?
The huge distinction, Your Honor, is that the Supreme Court specifically said in Lapidus that participation in the suit can consent to jurisdiction, whereas, of course, the black letter law is the opposite with respect to notice of claim.
It's statutory.
Yes, exactly, Your Honor.
It's not even black letter law, it's statutory.
Yes, Your Honor. If I may, the basic question of whether this defendant, which is not the state of New Jersey, had an 11th Amendment right in the first place. And I know this was not litigated, really didn't have to be, in Belfand and Henry where the consent was so obvious.
Well, I think for me, the difference is that the 11th Amendment is applicable to the federal courts, okay? That's where that kicks in, the 11th Amendment, because you go back to history, that's where it all came. That's the reason for the 11th Amendment, because two states got sued in the federal court, and that was like, oh my God. And the 11th Amendment passed immediately after that. This has to do with 2 states being sued in state court, correct? So that it's not really an 11th Amendment issue, but you get the instruction from Hyatt as to why it doesn't matter if it's in it doesn't matter if it's in federal court or state court. If it's in federal court, it's an 11th Amendment issue. In state court, it's a little simpler, not simpler, but the concept is sovereign immunity as a concept right there. It's just simply sovereign immunity, because we understand that when states became part of this great union, they didn't give up their sovereign rights. That was the bottom line. They still retained their sovereign rights. And that's what Hyatt 3 speaks to in terms of each state's own sovereign rights there.
Your Honor, I do not disagree with you, but that was actually, there's a more basic point, and it's not even addressed in Hyatt because it wasn't an issue in Hyatt.
Okay.
The 11th Amendment immunity does not apply to every public entity, every county, every water authority, et cetera. It applies to those that are arms of the state. In their main brief, the defendant argued that you, the First Department, are obligated to follow New York's federal courts. Unfortunately for them, the Second Circuit has a test
Counsel,
they can't possibly
I'm sorry to
pass.
interrupt you. Didn't we already find that it was an arm of the state in Fatahu?
In a footnote in Belfand, Your Honor, the court noted that the plaintiff conceded the point. It
No,
wasn't
that was in
litigated.
Belfand, but in Fatahu, but I may be mispronouncing, we did, I think, reach the question, and you answered it in the affirmative.
Well, I think, Your Honor, that you'll find when you looked at the briefs there, that the points that I'm making in the statutes I'm citing and the case law I'm citing none of that was cited to the court there. Every circuit has their own arm of the state test, without exception. Every circuit has their own. The first issue, therefore, is which circuit's test are you going to apply? Defendant argued in their main brief, you're required to follow New York's federal courts. They argue in their reply brief that no, you're required to follow the law of the circuit in which the entity is situated. And they say you can't apply another circuit's test, for example, the Second Circuit's test, to this Third Circuit entity. And they cite a number of cases, starting at page 17 to 20, that supposedly demonstrate that. Your Honor, those cases, every single one of those cases, the court applied, unsurprisingly, its own test. In most of those cases, it also happened to be the circuit in which the entity was located for obvious reasons. In 2 cases, it was not the case. The entity was outside of the circuit. One of those cases, Your Honor, and this is how they deal with that in their brief, page 22, the case involving the Puerto Rican Ports Authority. They say it involved a federal D.C. circuit entity. Your Honor, it involved the Puerto Rican Port Authority. That is located in Puerto Rico, which is located in the First Circuit. The D.C. Circuit applied its own test to the out-of-circuit entity. Morrison-Knudsen, at page 22 of their reply brief, they say that the court there in the Ninth Circuit applied its own authority because its own authority was based on a First Circuit test. Your Honor, Morrison-Knudsen didn't cite any, none, 0 First Circuit authority. The First Circuit hadn't come up with its test when Morrison-Knudsen was decided, and the tests are completely different. The First Circuit has a test similar to the Second Circuit's test. It's a 2-stage test. You get to the second stage only if you go through the first stage. The Ninth Circuit has a 1-stage, 5-step test. One of those elements is at neither stage of the First Circuit's test, and that is whether the entity is able to sue and be sued. But even if you go through the Third Circuit's test and you apply New Jersey statutes, which this defendant has not acknowledged, you get the answer that, of course, it's not an arm of the state. The first New Jersey element, Third Circuit element, is whether any judgment would be paid from the state treasury. That's answered by statute, Your Honors. 22:25-17, no debt or liability of the corporation shall be deemed or construed to create or constitute a debt, liability, or loan or pledge of the credit of the state. Not cited by them. Can I go to the last 2 elements, Your Honor?
Yes, please.
Thank you.
Mr. Schutter, it would seem that this is a case that might get to the United States Supreme Court, but some of these other issues that you bring up are not United States Supreme Court issues.
I'm sorry, I don't...
Whether it's an arm of the state or not may not ultimately turn out to be worthy of United States Supreme Court review.
That's very possible. They control their own review and they'll hear what they want to hear. But I think that doesn't alter the fact that when you look at the New Jersey statutes, this doesn't even pass the Third Circuit test. The second element of the Third Circuit test is whether state law regards the entity as a surrogate for the state. Your Honor, there's a provision of the New Jersey Tort Claims Act. That's the statute under which this case is brought. It specifically defines which entities are the state of New Jersey, for the purposes of New Jersey law. It says, quote, state shall mean the state in any office, department, division, bureau, board, commission, or agency of the state, but shall not include any such entity which is statutorily authorized to sue and be sued. Not cited to the court in any of their prior briefs in any of those cases, which I think is kind of a pertinent statute to know. The last element, the third element of the New Jersey test, is what degree of autonomy from the state. Another New Jersey statute, not cited by this entity, the corporation, meaning the New Jersey Transit Authority, the corporation shall be independent of any supervision or control by the department or by any body or offices thereof. Now, they bring up veto power. Veto power didn't mean anything to the Supreme Court of the United States in Hess, where it noted that the Port Authority was subject to a veto power, and yet nonetheless held that was not an arm of the state. Half Port Authority is not an arm of the state. The New York State Thruway Authority is, according to the Second Circuit, not an arm of the state. In Leitner, the Second Circuit ruled that notwithstanding the veto authority that this commissioner had over the individual activities of the board, there was no indication in the record that the state has control over its day-to-day operations. The Second Circuit ruled in Woods that although the Board of Education had, in theory, veto authority, the defendant had failed to cite any instance in which the State Commissioner of Education exercised such authority. I appreciate the court's indulgence on the time allowed. We do have an argument in our brief as to why this wouldn't apply, even if this was an arm of the state, why the benefit of the 11th Amendment doesn't apply to the individual being sued. I will rely on our brief. Thank you.
Your Honors, couple.
Counsel, I just want to say, when you left off, you started to say that this case was distinguishable from the other cases. Was that because of the pleading, or was that for some other reason you made that statement?
Oh, no. In Belfan, there was a trial, a mistrial, a concession of liability. In Henry, the case was up on appeal. In Fatahu, it had been litigated for 6 years. And in the very recent Taylor case, this court expressed concern, which I don't concede, but
you
the court
exerted
expressed
a
concern.
cross-claim.
Say,
You exerted a cross-claim in that case, in Taylor.
Thank you. Also, but in the opinion in Taylor, what the court says is, wait a minute, you waited until the Jersey statute of limitations expired. That's what's written in the opinion. And what I was talking about is distinguishing facts, Your Honor, is that none of those exist here. There's no trial date. There's no trial. Liability has not only been conceded, but when they filed a motion for summary judgment, it was opposed. That's still pending. Discovery isn't even over. There's a discovery motion pending. So it's in a different place factually within the case than the other 4 cases that the court.
What about statute of limitations in New Jersey? That's run, hasn't it?
Yes, the statute of limitations in New Jersey is 2 years. In New York, of course, it's 3. I will note that in Hyatt, the Supreme Court said that not only were the loss of costs of litigation not a factor that would eliminate or reduce waiver, but the loss of a judgment did not eliminate or reduce waiver. And in Hyatt
I got that point. But the problem with that, I thought about Hyatt 3 was that there wasn't the flip side of the discussion. It was obviously no discussion at all about how, in terms of litigation conduct, that factor into whether or not there was a consent to being sued in the state. I mean, Hyatt 3, I went and thought about it some more. That actually talked about a sister state being sued in another state in the state court. That wasn't a federal court situation.
Oh, Your Honor is absolutely right. And I'm agreeing with you, but what I'm saying is because of that, well, Your Honor is of good cheer. And because of that, because that is a federal immunity issue under Lapidus, and this is state,
I got it.
has nowhere to go.
You know what? Justice Thomas, when he wrote Hyatt 3, he had to hang his hat on some hook. And the only way he could hang his hat on the hook was to borrow the 11th Amendment analysis. That's where it all came from.
That's not what he wrote. Your Honor, I find myself in profound disagreement with the court. It's respectful disagreement, but the court wrote, Justice Thomas wrote, that this immunity does not derive from and is not limited by the 11th Amendment. And that's not my spin or interpretation.
Yeah, I got that. I'm not disagreeing with you. I got that. But the flip side of it also, you have Supreme Court precedent, at least I found cases that said, depending on what you do with your sovereign immunity defense that you have, inalienable, as according to Justice Thomas, it's there because you're all sovereigns, right? The flip side is, if the sovereign does something in another sovereign state, could that become deemed to be consent?
That's exception, which Your Honor wrote about, does not exist for this immunity.
Well, not yet, because guess what? It's probably going to go all the way up to the top.
I understand. But what I'm saying to you is, The trial court couldn't find it, you couldn't find it, the Court of Appeals couldn't find it. Because our lower courts cannot carve out exceptions to the Supreme Court. Now, what you just
I gotta
heard,
tell you, our powers here in the appellate division are pretty broad.
you're
We
a
have
very powerful
fact-finding
court.
abilities here. You know, we're a very unique appellate court from all the other 49 states.
And the issue is not so much are we carving out an exception, or are we just actually interpreting the law, the Constitution, as it should in fact be interpreted?
Well, given the quote that I've read to you that Justice Thomas wrote, it is my respectful but passionate argument that you can't go there. If that paragraph wasn't in there, maybe, for the sake of
Well, you know
argument.
what? I'll let the Court of Appeals and the U.S. Supreme Court tell me that.
Well,
Thank you.
I'm respectfully saying that.
Okay, I got it.
Do it. Now, what you heard in the argument here was all 11th Amendment law, but what he left out was a couple of things. One, as this judge said, and I apologize, I don't know all of your last names, what this judge said is that this court in Fatahu decided that New Jersey Transit is an arm of the state. The footnote to which counsel referred was where this court in Belfan, Your Honor will of course remember, said the other side conceded.
Still have nightmares about it.
But, Your Honor, in that footnote, Your Honor, since you wrote the opinion, cited Carnes. So when I, a lawyer, read the opinion, here's what I think. What I think is, if all you were doing was saying, well, they conceded it, it's not before us, you wouldn't have cited the case. In any event, after Belfan, this court, different panel, expressly found that New Jersey is an arm of the state. Moreover,
Yeah, you know what? You know what? My feeling is like Justice Friedman said. I mean, that's that's a side issue. The real key issue. Let's get to the heart of the key issue: is the sovereign immunity defense.
Well, no,
You know, whether or not you're an arm of the state or not. You know what? That's
well, I tend
that's
to
a cheap
agree.
way out. But the bottom line is the whole whether or not you have the sovereign immunity defense
Well,
and you exercise it. That's all.
I tend
got
to
it.
agree.
Yeah.
I only bring that up because I'm responding to the arguments
I
that
got
were
it.
made.
Thank you.
There's a New
Thank you,
York.
counsel.
Okay, thank you.
Thank you both. Morgan and Mendel versus Amster Rothstein. Yes, you may proceed.
Good afternoon. May it please the court. I'm Andrew Bluestone for appellant. Your Honors, the complaint adequately stated a cause of action for legal malpractice. It adequately stated the...
So, counsel, my first question is statute of limitations. Has not the statute of limitations run?
Legal malpractice? No.
Yeah, right, yes.
No. And it was never decided, the lower court didn't decide anything about that.
Well, okay, it may not have, but it's a 3-year statute of limitations, right?
Yes.
And so you filed 11/22/19.
Correct.
And so the start date would have been December 14th, 2012. So you would be beyond the statute of limitations.
Except for continuous representation and assignment, yes.
Okay, so for continuous representation, what's the tolling?
The tolling is work on the case well through November of 3 years earlier.
So,
I mean, pages 194 to 210 contain work that was done over that period of time and shows work that was done within the statute of limitations. And I'll note that there was no decision by the court from which there is an aggrieved appeal for the statute of limitations.
so in this case, Alan Miller tells Oster and Loke that the date of the first publication is January 11th, 2012, right?
That's what he says.
But in fact, the date of first publication was December 15th, 2011.
There were 3 dates of publication, that's correct.
And Oster and Loke had to know this.
Okay.
They don't correct him, do they?
They gave him the date of the paper publication of their paper. They didn't know that a squib some months earlier that says there's a paper coming out in March or several months from now constituted the first publication for purposes of the PTO. They gave him the correct date that they understood, the paper publication, when the paper came out in a magazine. And they depended upon the paper coming out in a magazine. They also advised him that there was an earlier online publication of the same article that came out in the magazine. And that's the date that Miller found on his own.
So your clients, Oster and Loke, did not know of the December 12, 2011 publication?
They didn't know of the importance or whether that date
Well,
had anything to do with
regardless of importance or not, I mean, it's the way I understand the patent law, it's all based on publication. They didn't think to tell that to the attorney?
They told him what they understood the paper publication to be.
So they omitted that. They omitted that fact. And
They
this legal malpractice, the way I understand it is you're framing it as if there's a duty to investigate from the attorney's point of view. I mean, that's a pretty broad sense of liability. That every attorney who, when a client tells them something, they got to investigate whether the client told them something accurate.
No, that's absolutely not true. And the
Well,
Green
that's what
case-
this sounds like. That's what's going on.
No, absolutely not. But the statute of limitations is very, very different from how an accident happened, or whether they had the red light in a car accident, or whether they were speeding. They have to know when they can file. This attorney investigated on his own and determined that he had until
But there's
date
been a
certain.
course of practice here between Einstein and the defendants. I mean, isn't there an invention disclosure form, which in question 16 says, provide information regarding any public disclosure of the invention. Basically, if this has been made public, you're supposed to let them know. That's supposed to be kept track of.
Yes,
And-
and they
and
gave
you are-
them
and
the,
you are-
they gave them the date of the paper publication.
So, yeah, but that date of publication was in December and not in January.
Yes, but don't believe that the first publication was a full publication of the entire paper. It was a small squib saying
But that
something's
made
coming
the
up.
material public.
That is true, but the attorney who went to investigate it, as an attorney with patent experience, who had to know what the first publication actually meant for
I'm
them.
glad you mentioned that, because when did you go and actually engage the attorney? Because the record here seems to say that they started working on the patent application on October 15, 2012, which is about 2 months before the one-year patent deadline if you took the December 2011 date, okay? So they only had 2 months. So is that correct, that October 15, 2012 is when they actually started working on it? That's when your clients conveyed them the information they needed?
It's unclear when they got the information, but what is clear is that Miller did an investigation and determined the date and had enough time as of that date to file something.
Well, counsel, I want to ask you, did the plaintiffs direct the attorneys to investigate? Did they say, you must investigate? Because I didn't see anything in there about that.
No, they didn't say you must investigate.
Well, direct, did they direct them?
Any more than an accident victim says, you must decide when the statute of limitations runs to file my case. He said, I had an accident on such and such a date. It's up to the attorney to determine whether that date is correct by looking at a police report. Just assure himself that it's
I just
correct.
don't understand why it was even necessary for the attorneys to investigate when the inventors, they know the first publication date, but I want to throw something else at you.
But they didn't know the first publication date because they got
didn't
the
tell
wrong
them.
one.
They didn't tell them. But let me ask you
No,
another
but
question.
when they looked themselves, they got the wrong one.
Okay, well, I want to ask you another question. So in the complaint, where in the complaint did they put any facts regarding the need and the reason to investigate? Is that anywhere in here, in the complaint?
No, the need and the reason to investigate are part of the attorney's standard of practice. They have to determine when the statute of limitations runs so that the application, the complaint, the petition, whatever it is that's filed for an attorney is filed timely. No one is going to excuse an attorney who says, I didn't really check the date of the accident, and I waited 3 years and 2 days to file the complaint. It's the obligation of the attorney, as part of the standard of care under PJI 2152, to determine what is a timely filing.
Thank you, counsel. You have time on rebuttal.
May it please the court, my name is Ted Poratz for Amster, Rothstein, and Evanstein.
I understand that it's your position that there was no malpractice here. I understand that. But let's assume that there was malpractice. What was that malpractice? The failure to discover the December 15, 2011 date?
The allegation that is made by the complaint is that the malpractice was failing to discover the December 11, 2011 squib, as the counsel refers it to. And instead, though he concedes
Because
that...
the significance of that date is that the application has to have been filed within 1 year of December 15, 2011.
If that's the operative date, that's correct, Your Honor.
So now, when it's not filed, that's when there's malpractice. Is that not so?
If the attorney had the obligation and failed to comply with it, to know that date,
We're assuming without finding, but we're assuming that there was no malpractice. So the malpractice occurs on December 15, 2012, when the application is not in, an application which should have been in if, according to plaintiff, the defendants were doing their job correctly.
that is an argument. But to Justice Weber's
This
point,
action is commenced on November 22nd, 2019.
precisely what I was
That
about
was
to
my
say.
point. So therefore, we're beyond the 3-year statute of limitations.
By a factor of many years. And that's
But
why
your adversary stated that, was this never brought to the attention of the motion court? Because he's stating that was never ruled upon.
the motion court ruled that the plaintiff did not have standing, and they didn't have standing because they didn't inherit the relationship between Einstein and my client. It necessarily follows, although not said specifically, that if they didn't inherit that relationship, then the clock starts ticking again anew. And you, as a de novo court on this matter, can certainly find that if a relationship formed at all between my client and Morgan and Mendel, which we say they didn't, but assume it for the sake of argument, that relationship wouldn't have formed a day sooner than March 16, 2016, and they're still 8 months too late. The court's decision was focused on two basic premises. One was standing, and I think we've discussed that already. Keep in mind, however, that, that under Section A1 of 3211, the complaint said in very specific language that their right derived from the licensing agreement in March 2016. The court examined that agreement. There's nothing in there that remotely speaks to an assignment of an attorney-client relationship, even if such an assignment could be done. Needless to say, and putting aside the fact that counsel has confused the difference between a licensee and an assignee, they just don't step into the shoes of Einstein for purposes of an attorney-client relationship. They've got to form their own. And once they form their own, the continuous representation rule goes out the window, because there's not continuous representation by definition. There is discontinuous representation.
The fact that the appellant, the fact that they were paying the legal bills of the defendant doesn't matter, because there was still a break in the relationship.
Well, not just that, Justice Moulton, but the license itself required Morgan and Mendel to pay those bills. Again, this application continued to belong to Einstein, which is probably why the license didn't assign a right of malpractice, if there was any, and nobody knew anything at all about this in March of 2016 before the Patent Office acted. But if there was some malpractice, it would have belonged as a cause of action to Einstein. So it makes an awful lot of sense that they wouldn't have wanted to assign
you know, getting into the merits a little bit, I mean, the Einstein itself had doubts about whether or not these patent applications are ever going to get approved, right? I mean, they reluctantly sort of let it go through because they had 2 reviews or 2 reports saying, you know what, I'm not so sure that this stuff is novel here.
That's exactly right, and you'll find that in the Patent Committee's report on page 102 and following.
So I just have a fact question here. The records, it seems that the plaintiff came to you guys in October 15, 2012 to get the patent application?
The plaintiff didn't come to us at all. Einstein came to us.
I'm sorry, Einstein came to you in October of 2012 to get the patent application?
They said, here's an invention, here's the package, turn this into an application, please, and file it. That's
right, so at that point, there was only 2 months left before the 1 year, time period would expire, right?
That's correct.
So what happened in that 1 year, in that 2 month period? I mean, who I can't seem to figure out what went on. I mean, the information I guess they gave you, it's just,
Well, you have to take a patent application, which is a chunk of data. You have to talk to the applicant, Einstein, and find out what exactly it is you say this data does. You have to make claims. And as we discuss in our papers, there are broad claims and narrow claims. There are kit claims for applications, and there are method claims just for methods. So you've got to find a way to figure out, A, all the things that you want patent protection for, all the things this invention does, all the things that may not be covered by another patent.
sounds like the suit should have been against Einstein. Okay, I got it, thanks.
May I just add one sentence to the discussion?
Yes.
I would like you, in addition to the discussion on standing and on the duty to disbelieve one's client, to consider whether this is not an appropriate opportunity for you to reaffirm your decision in the iGen case, where on all fours with that, they've got no damages, even if everything else works for them and it doesn't. Thank you all, Your Honor. First time back to court, thank you for the opportunity.
Welcome back.
If respondent's argument is that they didn't have enough time to do the job, they shouldn't have taken the assignment. It's not a defense to say, I didn't have an awful lot of time, so I shouldn't be held responsible for not filing within the time period. Now, on page 194 of the record, we see that on November 26th, Alan Miller wrote, I've reviewed the publication history here, and I see that we have a certain amount of time. I'll file within that period of time. He did not adequately investigate the publication history. He came up with the wrong date, and then he filed just a couple of days before the wrong date. So obviously he had enough time to file. He just had the wrong date to work on. He could have filed a couple of weeks earlier and been within the time period had he done an adequate
Yeah, but he got a lot of that information from Einstein. He got a lot of that, all that fact stuff.
But he
came from
checked it
Einstein.
himself, Your Honor, and then he checked it negligently. He took on the job of checking. He didn't just say, okay, Einstein tells me this is the date, I'm going to rely upon it. He checked himself, and he found a date that was wrong, and he relied upon it. As for standing, there's definitely near privity, if not real privity. Near privity, they relied upon the documents that were being prepared. Defendants knew that they were relying upon the documents, and they comported themselves in a way that linked them to the plaintiffs, who selected, directed, and compensated the attorneys. They have privity, near privity, and they have assignment as well. It's legal malpractice to pick the wrong date for the statute of limitations and then file it.
That would be an interesting predicament if I would agree with you and let this case go forward, that the law firm with third party in Einstein saying, well, Einstein, it's all your fault. So you'd be suing and ended up suing the guys that actually you work for.
Find
I don't
the
know if
plaintiff,
that's-
Your Honor. If that's what they want to do, they have the right, but that's not the point.
Okay.
There is a claim made against them that's adequate.
Thank you both.
Thank you.
10-House 2019 versus New York State Liquor Authority. Counsel, you did not request any time on rebuttal. You're aware of that?
Yes, Your Honor.
Okay.
Good afternoon. May it please the court. Stephen Armstrong on behalf of Appellant New York State Liquor Authority. I'm happy to answer any questions that the panel has, but there are a couple key points that I want to address during my time. The first of which is the lower court's decision. On its face, I think it's clear that the lower court judge respectfully did not conduct a rational basis review as required. There's no discussion of why the authority was not justified in relying on the police reports. The judge appears to simply...
Well, he said that the police reports were merely allegations, that there had not been any convictions, I guess, or final determination.
Yes, what's implied there is that because there are either no concurrent criminal charges brought, or because there's no indication that the district attorney's office had chosen to pursue charges, that therefore the reports were too speculative for the authority to rely on. And that standard, or at least the standard that's implied there, that there must be associated criminal proceedings for the SLA to rely on police reports when making character and fitness determinations is unprecedented.
He also said that it was clear, or he believed that there was some issue as to whether or not petitioner understood English, I guess, understood the English language when filling out the application in terms of loans and where the monies for the business was coming from?
Yes, so there were, in the request for reconsideration that the applicant submitted, it became clear there were material misrepresentations of fact in the original application. The most important of these being that the applicant had claimed that they would be self-funding the venture with funds from their personal bank account. In their request for reconsideration, in their affidavit, the applicant said they'd received hundreds of thousands of dollars in loans from sources that were never disclosed to the authority in the application. And yes, the lower court did conclude that he felt that these discrepancies were not purposeful, in part because of the language barrier claimed by the applicant. But going back to the issue of the criminal convictions, there are First Department cases which are more fully described in our papers that support the SLA's reliance on reports where there's no concurrent criminal proceeding. And of course, that's where there are indicia of reliability and that the reports have not otherwise been rebutted or discredited. And the lower court's approach here is a radical departure from precedent in that it ties the authority's ability to fulfill one of its statutory purposes, which is ensuring that applicants meet character and fitness standards, to charging decisions of district attorney's offices, which have their own priorities, their own policy goals, and their own limitations on the resources. So the fact that criminal charges were not brought or were dismissed or adjourned in contemplation of dismissal for regulatory violations, that's violations of the Alcoholic Beverage Control Law, it should not have any bearing on the authority's ability to weigh those violations when making character and fitness determinations. And I also want to emphasize that applicants do have the opportunity to challenge the authority's reliance on any materials, including police reports, during or through a disapproval hearing. Whenever an applicant has their application disapproved, they can request a disapproval hearing. This is a full administrative hearing.
Yeah, so what you're saying is, and I'm hearing, is that it doesn't necessarily have to, summonses or violations doesn't have to be directed specifically at the applicant. It could be, people who patronize the establishment, who go there. I mean, all sorts of things are within the liquor authority's ability to look over, right? I mean, it's an encompassing, it's a holistic encompassing analysis that they're looking at.
Yes, Your Honor, but the applicants do have a duty to properly supervise the licensed premises. Now, certainly doesn't mean everything a patron does inside or after leaving is necessarily.
And correct me if I'm wrong, in this record here, they actually increased security because of some of the problems that they were experiencing. I thought I read that somewhere.
Yeah, in the request for reconsideration, the applicant did claim that they would be increasing security to deal with future issues. But on the issue of the disapproval hearing, it's a full administrative hearing before an administrative law judge. The applicant can call witnesses, introduce evidence. They could call and cross-examine the police officers who took the reports. And the question before the ALJ in a disapproval hearing is, in light of the evidence offered by the applicant, did the authority have a rational basis for making its determination? So they do have the opportunity to challenge any police reports that the authority might be relying on. And in this case, the applicant chose not to request a disapproval hearing. As I said, they chose instead to request reconsideration. And thank you.
Thank you.
Good afternoon. May it please the court. My name is Niall Cook. This is my first time arguing before any appellate court, so thank you for your time, and it's an honor to be here.
Well, you'll see. Just wait a while.
So the appellant or the respondent requests this court uphold the decision of Judge Engoron in the Supreme Court below. While it's true, as my esteemed colleague suggests, that the SLA does have wide discretion in these determinations, it's simply not unfettered discretion.
Counsel, did petitioner's principal's admission that he upped security at the premises as a result of these alleged incidents constitute an admission that the police reports were correct?
No, Your Honor. Mr. Shamugia, the principal of Penthouse, simply sought to do everything that he could to maintain and continue on with his business and facing the denial that he faced from the SLA, he thought, the best case would be to increase security. He was trying to do everything that he could, and unfortunately, it caused him to invest more money into the company, in which, at this stage is still, defunct or non-operable. And as Judge Angoran suggested and pointed out, specifically in his opinion, that leaving this case or leaving this company unoperable would essentially be a forfeiture, and specifically requested or ordered that the SLA expedite its rehearing process.
So counsel, the test is whether it was rational, whether it was arbitrary and capricious. Given the fact that you have 4 violations, I think at least 2 were assaults, if I'm not incorrect. So you have these 4 violations that took place on the premises, and then you have misrepresentations made in the application by the owner. Can you actually say that their determination in terms of disapproving or not approving the application was arbitrary and capricious?
Well, Your Honor, yes, we would. We would say that it was extremely speculative. And actually, at the time of Judge Angoran's decision, there was one of the police reports had been dismissed. Another was pending. The one that you referred to didn't actually take place on the premises, but took place in the parking lot. And the final one was still pending, which was against against Penthouse. However, at the current time, all of the actions against Penthouse itself, all 3 except for the one against the man in the parking lot, have actually been dismissed, or the final one is currently in ACD adjournment in contemplation of dismissal.
Well, counsel, the bottom line is that the petitioner didn't challenge the NYPD reports and only requested a reconsideration. And in reading the affidavit, it seems to me that they the petitioner corroborated the things in the report about, the need for security.
Well, Your Honor, like I stated, he simply was trying to do everything possible to get his business up and running again. He has denied these allegations, and he personally doesn't have, the personal knowledge to put in an affidavit to say these things categorically did not happen. He's the manager of the premises, the owner of the premises, but, without a full inquiry into all of these matters, which other attorneys handled in the Supreme Court, resulting in dismissals, he simply can't make those statements. It would be
So we'll go to another area. So what about, the prohibition of sale of alcohol to underage persons, and also the sale of alcoholic beverages without obtaining the appropriate license? And certainly Rule 42 indicates that each licensee should be held strictly accountable for the violations that occur in the premises. So you have a violation, selling to underage persons, certainly selling alcoholic beverages without the appropriate license.
Again, Your Honor, the SLA continues in its papers to say that the Penthouse has been caught doing this or has violated that. However, as the record shows, and as we have the benefit of hindsight now, there were no violations. They were not caught doing anything. Everything has been dismissed. There were no violations. So the decision is based upon nothing but speculation of future potential violations, which Judge Angoran specifically stated in his opinion.
Well, what about the misstatements regarding the financing and the loans? Because clearly, those were misstatements.
Yes, Mr. Shamugia specifically addressed the financial issue or the financial misstatement. He said that he believed it was asking him his personal investment at the time. And as his, he did it through an insurance broker who claimed she could do it. Clearly she could not. She was incompetent to do it. When he makes his reapplication, those issues will all be resolved. And simply to not allow even a reapplication or a rehearing or on this would be a forfeiture of this man's entire investment, his entire savings, $700,000, loans from friends and family, and crush a honest working man's American dream.
Thank you, Counselor. Excellent job. Welcome to the Appellate Division.
Thank you.
Whedon versus Lukev? What, you got another one now? Wow.
He doesn't get the second one.
No, he's an all-pro.
He's an all-pro.
May it please the court, my name is Niall Cook. On behalf of appellant Amber Whedon, I'd like to start off by saying simply that the Supreme Court, Judge Feinman, applied the wrong standard. She stated in her opinion that the appellant was asking the court to believe her without any discovery. Well, that's exactly the position.
What allegations do you have in the complaint of defamatory statements made by any of the defendant lawyers?
The defendant lawyers. Yes, Your Honor.
That's what this appeal is
Yes.
about, a
Yes.
claim for defamation against lawyers. That's the issue on the appeal, premised upon the fact that they filed this lawsuit against your client.
Yes, Your Honor. Well, first of all, we do believe that the defendant lawyers stated to the New York Post and other places that specifically the appellant, Amber Whedon, was a prostitute, specifically that she was under investigation by FINRA, and specifically that she offered her services on some website called Eurostar.
You state that based upon information and belief. I mean, there's no question that they forwarded the complaint to the New York Post reporter after the complaint was filed. Isn't that something which is privileged under Williams and the Civil Rights Section 74?
No, Your Honor. This case fits squarely within the exception to Civil Rights Section 74 in the sham litigation exception, in that people simply can't, where a party files a complaint containing false and defamatory statements.
So you say it's sham litigation, but there was several dismissal motions. There were dismissal motions made against that complaint.
Yes.
And the complaint survived those motions. Is that correct?
Yes, there was a dismissal motion, and Judge Hagler, he did not outright deny the motion. He suggested that it be brought in a summary judgment motion later after further discovery, which is essentially what the court in this situation should have done.
Could you have moved to strike defamatory matter or scandalous matter in the pleading, in the Lukaszek matter, before Judge Hagler? And so, in addition to moving to dismiss, it's also possible to excise information from a complaint that is said to be scandalous.
Yes, yes, they could have. However, that's not the issue here. The issue is that these defendants stated these not only in the complaint, but outside of the complaint to other people. It's not simply, we're not simply pointing the complaint and saying those are the defamatory statements. We're pointing to those statements as they were spoken to other people, to the reporters, to the prosecutor in Mr. Lukaszek's criminal defense case, and potentially others.
Do you any place in the complaint say that Mr. Lakowitz said anything specific? Is there any defamatory comment by Mr. Lakowitz that you point to?
Well, Mr. Lakowitz is, we don't have the internal communications of the law firm, of course. So we can't say
Well, do the
specifically.
internal communications of the lawsuit support a defamation action?
I'm sorry, can you repeat that?
Do the internal communications of what the lawyers are talking about in their office does not support a defamation action?
Well, it does also support a conspiracy theory of defamation between the different parties. You know, you have
No,
the
but the
case of,
question is whether that would be discoverable or not. Would that not be confidential?
well,
Would it not be privileged?
it may or may not be, but that's a inquiry.
But don't you have to allege that in bringing a defamation? Isn't there a need for specificity when you're alleging defamation?
Yes, there is. And as I stated, the complaint does allege specific statements made about that the defendant or that the
It just doesn't attach it to any person.
yes, because we don't know. We know that the law office contacted the New York Post. We know that the law office did this and that. We don't know who exactly at the law office did that.
There's nothing defamatory as such in the law office contacting the New York Post.
No, but it is when they state that she is a prostitute and that she advertises on
But
Euros.
you're not able to say that. You're not able to say that so-and-so said that she's a prostitute. You don't allege that.
Excuse me, what was the question?
Mr. Lukaszak obviously made this charge, and you do allege that in the complaint. But we're not talking about Mr. Lukaszak. We're talking about the lawyers.
Yes. Yes, and it's uncontroverted that the lawyers were the ones who contacted the New York Post. It's uncontroverted that the lawyers were the ones who sent the complaint to the New York Post before it was even assigned an
But the
index
question
number.
was whether or not you have to allege in the complaint with specificity exactly who the lawyers are other than Mr. Lukowitz.
Well, since Mr. Lakowitz was the attorney of record, it can be presumed that it was him. That's kind of the, you know, maybe it was someone else in the law
Does pleading in a defamation case accept that we're going to presume that he made this statement? And just by the way, in terms of this sending it to the New York Post, he sent it to the New York Post after it was filed.
Immediately after it was filed, moments after it was filed.
It's a public document.
Yes, correct. However, you cannot, as the sham law exception states, where a party files a complaint containing false and defamatory statements for the sole purpose of subsequently publicizing those statements to injure the defendant, it is not privilege. Moreover, Mr. Lukaszak has withdrawn all of his complaints against, and all of his claims against Ms. Whedon, further evidencing that it was a scheme.
They wasn't consolidated with the other lawsuit?
It was consolidated first, and then it was recently withdrawn on all of his claims. He filed a motion to discontinue all of his causes of action with prejudice.
Does the record tell us why it was withdrawn?
It does not. All we know is that on August 15, 2021, he discontinued all of his claims against Ms. Whedon with prejudice.
Thank you. Your time on rebuttal.
Thank you.
Good afternoon. May it please the court. My name is David Slarski, and I represent Moses & Singer and one of its partners, David Lakowitz. The essence of this dispute is really that Ms. Whedon, the plaintiff appellant, sued the Moses & Singer defendants, asserting that they had defamed her, first by filing a complaint that was verified by one of their clients, and second by truthfully responding to media inquiries about the complaint. The trial court correctly dismissed the claim based on the general rule that lawyers cannot be held liable for in-court statements or for fair descriptions of judicial proceedings, even if the parties vigorously dispute the allegations. Upholding the principle in this case is particularly important to protect Moses & Singer defendants because—
What if before the lawsuit's filed, I agree with you what you just said, your statement's, I think, spot on. But what happens if before the lawsuit's filed, that there is a reach out, somebody reaches out, and let's assume that the law firm reaches out to the media and starts telling them about what they're going to do, does that change the dynamic? in
It
terms of a
might,
legal
but that's
matter?
not what's alleged in
Wasn't
this
the
complaint.
complaint alleged that there wasn't anything said before they told the reporter, we'll talk to you after we file the case?
That's correct, Justice Friedman.
That's what the complaint says.
That's correct. The allegation at R23, paragraphs 75 to 76 in the complaint is that the New York Post reporter discovered Ms. Whedon's.
Paragraph 78 of the complaint, that the attorney spoke with the reporter from the New York Post and told her of the imminent filing of the lawsuit and that they would send it to her upon filing.
Correct, but there are two lawsuits here, Your Honor. The first lawsuit is filed on October 22nd by Ms. Whedon. She files a summons with notice, and one thing that's
I was referring to the Lucas Act lawsuit, which is the subject of this appeal.
I'm sorry, I didn't hear
I
you.
was referring to the Lucas Act complaint, which is what the defamation is about.
Correct, Your Honor, but if you, this is what, to answer.
It goes to my question in terms of timing, because the New York Post is, what I think I'm hearing is that they're the ones who found the plaintiffs.
That's what's alleged in the complaint, Your Honor, and that's exactly why I was saying it's so important to uphold the principle, the general principle here, because if you track the allegations in the complaint, Ms. Whedon files the initial lawsuit by summons and notice. That summons and notice is graphic. It's not quoted in our brief, but if you look at it in the record.
And the New York Post gets that.
The New York Post finds that, and then the allegation is that the New York Post, not Moses and Singer, not Mr. Lakowitz, don't confuse Lukasik with Lakowitz because that happened below, but not the Moses and Singer defendants. Their allegation is that the New York Post, trolling the docket, finds this scandalous notice and summons that they file, that their lawyer is quoted in the press talking about, and reaches out to our client, and reaches out to our attorneys, presumably because they're tipped off by their lawyer.
Right,
Moses
and so does
Singer
that then
representing.
give rise to the inference that then you went into damage control mode? And anyway, is that an inference that could be drawn from this complaint? That the proximity, the initial press interest, it was like, oh, we've got to deal with this, let's get out in front of it, so let's file our complaint, which contains these allegations about her being a prostitute.
All you need to do is infer what's written in the complaint to realize that this is not a defamation claim. You don't need to draw inferences in favor of
Is it
my.
also true that the New York Post article doesn't even quote defendants' attorneys?
That's correct, Your Honor.
Well, Mr. Salnick is quoted, isn't he, in the initial?
He's a Florida attorney not affiliated with Moses and
But
Singer.
these defendants are not quoted in the New York Post.
The Moses and Singer defendants are not quoted, okay? There's a very artful pleading maneuver going on here. The plaintiffs have pleaded this by lumping in the Moses and Singer defendants and Mr. Lakowitz with Mr. Salnick in Florida, who is quoted, the criminal defense attorney is quoted in Florida in the Palm Beach Press and in the New York Post. The only other attorney quoted in the New York Post is plaintiff's attorney, who's jumping up and down about the scandalous complaint that he just filed for Ms. Whedon, okay? This is why it's important to uphold the principle.
What's in front of us is only Moses and Singer and Lakowitz.
Correct, Your Honor, and I want to make this point very, very clearly. The Moses and Singer defendants, there is nothing anywhere in the complaint that identifies anything said by the Moses and Singer defendants. In fact, it doesn't even allege that the Moses and Singer defendants spoke to the Post or sent the complaint.
But I thought it alleged that Mr. Lakowitz, who is with Moses and Singer, did speak to the press.
No. What's alleged is that the attorneys, now the attorneys is defined to include Salnick down in Florida and the Moses and Singer defendants up here in New York. They artfully combined them in the allegation. This is why it's so dangerous to let a defamation claim go forward that isn't specified with the allegations.
Counsel,
Salnick is quoted
if I may, counsel, plaintiffs are claiming, all right, this is a sham lawsuit. The only purpose in filing a lawsuit is to disseminate defamatory information. So if that's the allegation, isn't that a factual issue that has to be determined at trial? I mean, how can you show that just on a motion to dismiss?
I'm going to give you 4 reasons very quickly because I see my time is out. 1, it's not alleged in the complaint that this was a sham litigation. What this is an argument that was made in response to our motion to dismiss when they realized we had them dead to rights and they found an exception under Williams, which is a very unusual case. It's not alleged in the complaint that the underlying litigation is a sham. 2, It can't be a sham because Ms. Whedon filed the first lawsuit. There is a bona fide dispute between these parties. Sham litigation doesn't mean that somebody's not going to prevail or that somebody's...
Sham litigation survives dismissal motions.
3, the sham litigation survived 11 motion sequences and was litigated until it was consolidated and is continuing to be litigated. The dispute is being litigated. And 4, the Williams case is a very unusual situation where the filing party then takes the lawsuit and goes out and flogs it when there's no genuine dispute between the parties, but they're just doing it to affect the reputation. They're doing it to injure the other party. Here, Moses and Singer and Mr. Lackowitz didn't go out and flog the lawsuit. It was discovered by the New York Post in response to Ms. Whedon's filing. And 2, there's obviously a real dispute between these parties, whatever the merits are.
And obviously holding that these lawyers are subject to being sued for defamation because they filed a complaint is no small holding.
This is why it's so important to uphold the principle. If you permit this claim to go forward into discovery, et cetera, it is open season on lawyers in this city to step into highly charged personal disputes as took place between Ms. Whedon and Mr. Lucasek. Now look, let's be honest. Those allegations, one of those parties, it's either a horrible misunderstanding or there's a serious dispute between those parties. But both of those parties are entitled to vigorous representation and restrained representation, which is what Moses and Singer and Mr. Lackowitz gave. If they are hailed into court for defamation, when the only lawyers who are quoted in the press are Salnick down in Florida and the plaintiff's lawyer, who's jumping up and down and probably tipped off the post, had to have tipped off the post to the fact that Moses and Singer was representing him, because there's no reason for the Post, based on their notice and summons, to call Moses and Singer. The only way they do that is if they call the plaintiff's lawyer first, and the plaintiff's lawyer says, go call the defendant's lawyer. This is who's representing them. I've got a big story I want.
I got a quick question. So that what I'm hearing is, okay, the lawsuit, the defamation lawsuit that Plaintiff Whedon has commenced here against Lucasek and your firm. What happened, the merits with Lucasek, that's separate from your issue. Your issue is, look, we're the defendant law firm. The allegations here just don't make out a defamation claim against us lawyers. That's it. I mean,
That's exactly.
Whatever happens to Lucasek, that's his business.
That's exactly right, Your Honor. Under Civil Rights Section 74 and Khalil versus Front, which they never address, or Front versus Khalil, I always reverse them. They never address the common law immunity for in-court proceedings. They just ignore the case law. Then they say, because we show them the law, then they come back with the sham litigation Williams argument, and there's ample reasons why this, as alleged, if you take their allegations as true, if you take their allegation as true that Ms. Whedon filed the first complaint, if you take their allegation as true that the Post found it on the docket and reached out to Moses and Singer, that it wasn't Moses and Singer out there flogging the complaint, if you take their allegation as true that these actions were later consolidated, I guess that's not an allegation, but it's a matter of record. If you take the facts as they're given, it cannot be a sham litigation. There is a bona fide dispute. And, you know, on behalf of Moses and Singer and Mr. Lackowitz, one of its partners, I respectfully ask that the court put an end to this, which has been going on now and held a cloud over their reputation for, more than a year.
Thank you, Counselor.
Thank you, Your Honors.
Quickly, I would like to address that the word sham litigation may not be contained in the complaint. The complaint does plead facts which support the theory. And moreover, this court in Hylicon Jets Inc. v. Jets One Group stated that once a defendant makes such an allegation that a lawsuit is intended for the purpose of harming or causing damage, once that allegation is made and sufficiently pled, it cannot be decided on a motion to dismiss.
Well, see, Counsel, we're back to the specificity of the pleadings in terms of Moses and Singer and the attorneys other than Mr. Lackowitz. So where in the complaint, or do you not have to allege in the complaint what specific attorneys for Moses and Singer did?
Well, yes, and again, there's also the idea of the theory of a conspiracy of defamation. If these attorneys advised, Mr. Lukasik wouldn't know to do this. He wouldn't know to make these claims and then in his FINRA report not make those claims and do this and that. So if these attorneys advised him and coached him on how to do this, it would, I take the position, we take the position that it would be a horrible public policy to go the other way and decide that anybody can say anything about anyone and then file a lawsuit after, and then you're scot-free. That is the purpose of the sham litigation exception, and that is why we're not requesting that this court decide liability. We're simply asking for some discovery, some time to go and find out the truth. I'm sure.
How do you then, in terms of sham litigation, what effect do you think that would have with respect to the defendant, my understanding, he withdrew his complaint?
Exactly, yes. Which goes to support the idea that the claims were completely unfounded, and before filing them.
Well, maybe you have a more
survive-
solid claim against the defendant individual, but maybe not the law firm, but that's, I'm just thinking
Survived a
that.
lot of dismissal motions. We're not talking about Lukaszak, we're talking about the lawyers. It survived 11, that litigation survived a lot of motions.
Judge Hagler, my reading of the record below is that Judge Hagler suggested that it be brought on a summary judgment motion later and not, he dismissed it without prejudice, or he denied the motion without prejudice and suggested that after discovery it be brought again.
Thank you. Thank you both.
Thank you. Good job.